There are three different things in Florida called homestead, and almost everybody confuses them. Today, I'm only talking about one of them. I'm David Shulman, and I'm here with my partner, Jill Ginsberg. Quick map first. When people say homestead in Florida, they mean one of three things. One is the property tax exemption, two is creditor protection, and three is about what I'm talking about today, the devise and descent restrictions, the rules about who you can leave your homestead, your house, your home to when you die. That's in the Florida Constitution, and this is where we see estate plans blow up.
Why is this the one that causes problems?
Because people assume their house is theirs to give away. It's not in Florida. If you have a spouse or minor child, and this only matters if the house is titled in the decedent's individual name. If it's owned by husband and wife, or husband and husband, or wife and wife as tenants by the entireties, the survivor just inherits by operation of law.
Okay, individual name. Walk us through it.
The Constitution, that is the Florida Constitution, not the U.S. Constitution, if the owner of a Florida homestead is survived by a spouse or a minor child, the owner cannot freely devise, which means give away at death, the homestead.
So what happens?
It depends on who survives. If the decedent is married and has no descendants, the spouse inherits the homestead outright. Done.
And if there are descendants?
Now you have to ask whether any of them are minors. If the decedent's descendants are all adults, the owner can still devise the homestead to the surviving spouse outright. Adult descendants don't trigger the restriction. But if the owner tries to leave it to the adult kids instead of the spouse, then 732.401 Florida statute kicks in, and the spouse receives a life estate and the descendants get the remainder.
That's a mess.
It is a mess. The spouse has to pay taxes, insurance, maintenance. With the life estate, the spouse has to pay all these things. Now, the descendants own the remainder and have no obligation to contribute. The spouse can't sell, they can't refinance, they're stuck.
Is there a way out?
Well, 732.401 and 2 gives the spouse the option to take an undivided 1/2 interest as a tenant in common with the descendants instead of a life estate. But there's a 6-month deadline from the date of death. Most people don't even know the deadline exists. I've been called by surviving spouses 2 years after the spouse died, the first spouse dies, asking why they can't sell the house. At this point, there's nothing we can do.
What about that minor child scenario?
Well, that's even worse. If there's a minor child at the date of death, even one, the homestead cannot be devised at all. Not to the spouse, not to anybody. Strict constitutional prohibition.
So what happens to it?
Same as before, 732.401. Spouse gets the life estate, the 6-month option, and all lineal descendants share the remainder, and not just the minor. If the decedent had 1 minor child and 4 adult children from a prior marriage, all 5 share. The 1 minor child triggers the rule, and then every descendant comes in on the descent.
Even adult kids from the prior marriage?
Even every lineal descendant. And the minor child doesn't even have to be the current spouse's child. A minor child from any relationship triggers the rule.
What if the person tried to leave it to the spouse outright in the will?
If there's a minor child, it's void. The constitutional rule overrides the will. I've seen wills that leave everything to the spouse, and the house still passed 732.401 because there was a surviving minor child.
What about a trust?
Well, a lot of people think that a revocable trust avoids this, but it doesn't. The same analysis applies.
So is there a way actually to leave the homestead to somebody other than the spouse?
Well, there are 2 ways. First, the spouse can waive homestead rights in writing, a prenup or postnup, or the spouse can also waive by signing the deed into a trust. If the homestead gets conveyed during the owner's lifetime and the spouse signs the deed, the signature is treated as a waiver, so you don't need a separate agreement.
Does the waiver solve the minor child problem?
Nope. As I said, the waiver only works against the spouse. The minor child can't waive their rights. As long as a minor is alive, the homestead can't be freely devised at death.
So what's the answer if there's a minor child?
A specific type of irrevocable trust funded during the owner's lifetime. The owner deeds the homestead to the trust while alive, reserves the life estate, keeps living there, keeps the tax exemption, and keeps the creditor protection. The trust controls what happens after death, But because the transfer was a lifetime conveyance and not a devise, the minor child doesn't block it. There's even a statute, 732.4017, that confirms this work.
So you're moving the house out of your estate while you're still alive.
Right. It's a sophisticated estate planning tool. Not many people know how to do it. It's not just the casual documents, but for the client with a minor child, it's the right mechanism.
Takeaway?
Well, if you own a Florida homestead in your individual name and you have a spouse or a minor child, you don't have the freedom to give your house away that you think you have. Your will doesn't control it. Your irrevocable trust doesn't control it. The Constitution controls it. And when people find out too late, the surviving spouse, 6 months and a day after death, there's nothing we can do. This is why one of the first things I do when I speak with new estate planning clients is discuss their homestead. And that's it.